Remember, I'm just asking questions here.
Okay, I want you to see something, so bear with me. I'm gonna go over here to the document. Now, this is from May 18th. Now, do you notice how this lights up? This is a government document. You can find this on Pacer. It's case 10 CR 00326 DSD FLN, document 148, right? There's 272 pages, and they make it so you can't copy and paste. You can't use them. I believe that's done purposely, but we're going to focus in here on some government witnesses, and we're going to look at Ernest Kidwell and Scott Larson. And let me show you why we're gonna look at those two witnesses. I want to show you something. Okay, so after trial, now I'm filing my 2255, and just like you would be or your family would be, you want to get a fair adjudication, right? So in this case, I'm arguing that at trial, the government introduced computer evidence that it said it allegedly obtained from Ernie Kidwell, a former contract employee of me that did like bookkeeping and stuff for my real estate stuff. And it talks about a computer that he had gotten from me, but there was some chain of custody issues. He had it for a long time. And the FBI claims that they found a resume. And so this resume becomes like a big deal in my case because it's basically like, I guess I would have gave this resume to the mafia boss or something because it corresponds exactly with the government's indictment and says that I was taking advantage of banks and I ran a group of people that did this. It was a crazy ass resume that they just found, they claimed, right? And so what I argued is that here's the chain of custody issue. The actual computer was never found. It was never found. In fact, Ernie told me and told my attorney that it had gotten stolen, right? And so the FBI says that they went over there and made a copy of the hard drive at some point and all this stuff that they pulled off of it, including this resume. And they said I made these fake exculpatory letters.
Now remember, the government said I lied about everything and everyone and made all these fake documents, but then went to sentencing to try to enhance me and couldn't prove that. Couldn't prove it. In fact, lost on that.
Right? But they're trying to do anything they can to link me to this conspiracy, which doesn't exist. So they literally lie and create stuff that didn't exist. You know, when you look at my argument, I just want you to know that so we can look at what the trial transcripts actually say about these two witnesses and then look at what the court said in my 2255. It's going to be real eye-opening for you. Okay, so I know I'm taking a little bit of time here. I just want to make sure you have enough foundation, right? So we're focusing in on Ernest Kidwell, Scott Larson at my trial, what was actually said. And Ernest used to work for me, and this is Scott Larson, the computer expert. And so we're going to go skip down here to pages 213. This is Doc 148. You can get this off Pacer, read the whole thing. I encourage you to. There's so many funny things that go on at trials that you just wouldn't even know about. During trial, I kept telling my defense counsel, I said, Steve, I said, people don't realize what goes on in here. I said, this is absolutely outrageous. So Ernie comes in, he talks about who he is. He's doing pest control now, and he used to do like property management, some accounting with the rents, things like that. I delegated a lot of tasks to him. I would say he was, if you wanted to give him a fancy title, he was probably like vice president of all my real estate stuff. And here he says, and did Mr. Spencer have a company called Empire Lines? That was one of my companies, and he was a property manager. And we're going to go down because they're basically saying that there was a computer at Minnesota 1 where I did a lot of business at. And, was it located sort of near, was the computer? This is the evidence they used against me to tell the jury that they got this resume that was mine, that wasn't mine, and some other documents that they misled the jury on. And so it all starts years ago, supposedly with a computer that sat near my group at Minnesota 1. He says, yeah, is that fair? Yeah. And then at some point, this computer left. At some point, we don't know when. Where did it go? Well, it would have been to the second office, which would have been in Albertville. So when Mr. Spencer started working out of his home in Albertville, when was that? I can't honestly say. I don't know the exact. It was probably closer to 2006 if I worked in 05, 06. And so then McLaughlin says, and then at some point in 06, Mr. Spencer stopped working at the Sloan Place business location in Minnesota 1, started working out of his home in Albertville. Yeah, that's correct. And the computer went with him. It did. Yep. Okay. So this is where this crucial piece of evidence, one of the that they present to the jury, comes from, allegedly, right? It all starts here. And there were some hard feelings between us at some point. We went our separate ways, but nevertheless.
Now, when I say we, I mean Ernie and I. We were kind of friends, I suppose. At least I thought we were.
We remained in contact. It wasn't like, just because Ernie wasn't working for me, we might have had a disagreement. It wasn't like we still weren't friends, or at least I thought. So he still had some of my property. He had a computer.
And he might have, because I remember giving him one for his music business. Now, the one I gave him had a special sound card in it, and it wasn't the same compact Prosecutorial that was mentioned to have been near me years ago at the Sloan Place. That's number one. And then number two, the computer I gave him did not have a bunch of extensive business records for me or any of my businesses on it.
And now they're talking about in 2008 now. So this is, again, allegedly was maybe at the end of 06. We're in 2008 now. He allegedly gets another computer from me now in 2008. This is where he tells the agents he got the computer from. And he says, was it the same computer that was at Minnesota 1? And he said, I didn't take it apart, nor do I know exactly. However, I could say it's the same type. It's a compact Prosecutorial, right? I'm paraphrasing.
A plain reading of it is he doesn't know, right?
And so then Mr. McLaughlin, the prosecutor, says at some point, did this gentleman to my left, this is his case agent, Steve Hootsman, did he come out and see you? Yes. And he interviewed you? Yes. And during the interview, you told him you had a computer with information on it about Mr. Spencer, correct? Related to the company? Yes. And thereafter, Mr. Kunzman brought somebody else out to see you, correct? Correct. Was that a computer expert that works for the IRS?
What? Wait, what did he just call this guy?
As far as I know, yep. So, as far as Ernie knows, true or false, this is a computer expert. Now, did you specifically identify that computer expert, the file on this computer that contained documents relating to Mr. Spencer? Ernie says yes. Did you give permission to that computer expert to make a copy of that file and take it with them? Ernie says yes. Here's what I want to ask you. Was that a computer expert, number one? Computer expert, number two. Computer expert, number three. So if we look on document 148, page 219, they've referred to this man no less than 3 times as a computer expert. Do we agree? Okay, so let's go back to my 2255. I said the jury relied upon the IRS agent's opinions about forensically foundationless information to connect me to the government's theory of mens rea.
And so mens rea is knowing and willful intent. In this case, it was my knowing and willful intent to join a criminal conspiracy, which I denied. And I claim the government has no proof of this element, of this mens rea element. So to manufacture one, because they were so desperate to find anything, to try to force me to reach a plea or tell on other people, they manufactured this evidence.
Saying that I was prejudiced because he was calling himself a computer expert, right?
And now that's important because anytime you introduce evidence with an expert like that, you're telling the jury, you're kind of, endowing this witness with this credibility. He's not just a normal witness, he's an expert, right? And anytime you do that, there's certain standards. These standards were laid out in a case known as the Daubert case or the Daubert standard. And that's what I'm arguing here. Like none of this was done. You marched some guy up with some, unreliable, unverified evidence. And then as an expert witness, he told the jury that this links me to the crime. So if you want to know what, prosecutors do in their off time, well, they lay awake at night and they have meetings and they get together and they conspire about how to incriminate people, especially where they don't have any evidence, as I'm going to continue to demonstrate here. And then they overtly lie to people like they did my co-defendant, who will tell you that he was told all the way up until he got sentenced that he had immunity. And then they pulled some semantic argument on him and said they just agreed not to formally charge him. They never agreed to give him immunity. So at his sentencing, they basically dumped on everything that they told him he had immunity for. Now, this co-defendant testified against me in my trial. And while he was testifying against me, he believed that the government was, had this power in this agreement. They were going to give him immunity. He really believed that, and they allowed him to go and continue in this false impression that he had immunity while he testified on a whole bunch of people, right? And then at sentencing, his attorney says that it would violate my client's rights to even talk about this. He had immunity on this. Here's what his attorney, Chris Ritz, said, and this is in document 168, 10 CR 00326. I do not believe that it's fair or relevant to discuss in any form the Hoffman or Wegscheider cases, as Mr. Dose was never charged with these cases, was granted immunity on them, and had no opportunity to defend himself on any allegations surrounding them. Allocating any points to his sentencing on these issues, therefore, violates his due process and other constitutional rights. So if Chris Ritz is an idiot, Dole still thought he had immunity. But so this is filed almost 2 years after he testified against me. He still thinks this. Now, a lawyer's not going to argue that if that wasn't really said. But then they get to sentencing and now he don't have immunity no more. They back off that and they say, oh, well, yeah, I guess nobody said that. But my co-defendant will tell you that's exactly what he was told. He had immunity. And if he would have had it in writing, he would have felt like on the stand, I'm free to tell the truth. But if they would have only said it to him verbally and said, well, we'll put this in our back pocket till you get done testifying against Spencer. Well, that's kind of a little bit different, isn't it? Now he's not on the stand really feeling like he is free to say what he wants. And this is also the same co-defendant that after trial, right before his sentencing, he recanted any intention he had to ever join a conspiracy or that he thought he was doing anything wrong. He made an entire recantation right before sentencing. Same co-defendant. And this is the same prosecutor who's telling you that I'm the fraudster. Now, why do I say that? Now, this is going to shock you. Look at this document. This is actually from my prosecutor, David McLaughlin. Right, and this is in 2024. He's retired now after 25 years, and he's writing this letter on behalf of this person right here, Laura M. Provenzino of the United States District Court. He's going to talk about how she joined the office in 2010, and in 2018, she joined the leadership team of Major Crimes Division, and she had 150 such meetings. So when I say they get together and they have meetings about how to incriminate people, no, they actually do, right? And this is document. I can give you a copy of this document, but it's basically David McLaughlin, the prosecutor, talking about members of his team, and now he wants to get them promoted to actual district court judge, right? Let's get a member of the team promoted to judge. They could be referee now. And during the whole time that my stuff's going on, my trial, my direct appeal civil case, this person is on the team with David. So just so you know that. You wonder why the courts are rigged? Member of the team, official judge. We got it done. David McLaughlin got it done. This person who sat in 150 meetings was on the major crime unit with David, who you're getting to know through my case. Okay, so now let me show you my civil case and how David's related to this. This was filed 1/17/2013. This is civil docket 13 CV 00177. And this was a civil case that I had to file because while I was in prison, BOP guards came, snatched me up, threw me in the hole for no reason, just pretextual reasons, and then destroyed more than a foot of legal evidence, legal pleadings that I had for my appeal while my appeal was going on. So if you remember the dates, this is 1/17/2013. This is before my Supreme Court period to file my direct appeal has ended, so I still have Supreme Court time, and it's before I file my 2255. But on January 17th, 2013, I file a complaint. Now, look at how many documents are in this complaint, and you know I'm showing you how biased and rigged these courts are. So to get this to last this long, there's a lot of substance here. And this is in addition to all the documents in my criminal case, which we'll talk about when we get to my 2255. But this is going on while my direct appeal, while my 2255 is going on through that whole time. It started in 13, went through at least 2017, 2019, and it was dismissed, not giving me a jury trial because they had immunity and because the court dismissed it basically because they didn't want me to bring witnesses in that would have testified that, yes, I did send Spencer that exculpatory evidence or I did do this. They didn't want me to develop that because it would undermine their criminal case. So they cheated me in this one, spent a lot of money trying to do it. So we got to be thankful for that. But keep in mind today, 1/17/2013, I file a civil action. Okay, so now here's where I'm going to tie it in. This is when I was snatched up, thrown in the hole, transferred around. And here was the rationale for the transfer. It says on January 8th, 2013, documentation was received from USA David McLaughlin stating inmate Spencer should be separated from inmate Doles. He's telling them all this is going on. They came and snatched me up, took my evidence. It never showed up at the next spot, which I proved in that civil case. That went undisputed, that a foot of my legal work evidence disappeared. And I filed that complaint about a week after this, right? Because, I mean, can you give me a little bit of time if I'm snatched up, thrown in the hole, right? But I didn't find out about this. They didn't tell me this. They hid this from me. Right? But here's David, after my co-defendant thought he had immunity, after he testified against me with false pretenses, all the stuff I'm arguing, my direct appeals going on, I'm writing the court and saying, hey, listen, I can't get a hold of my attorney, I get snatched up, and he's involved, right? Here he is. So he's not only, the prosecutor, but he's kind of also the executioner of the sentence now too, isn't he? This is now a judge. You wonder why.
And so keep that in mind.
So the clock's running now. I get to the new spot and I only have a little bit of time to file my 2255. I wasn't able to file to the Supreme Court. Now, without any of my important legal materials, I have limited time to file my 2255. This is my last chance. So I need to raise my issues and I'm trying to get the record, get some transcripts, but I can't. And the court tells me you don't need those. So I file as detailed as I can my 2255 complaint.
Okay, so here's what I want you to be aware of too. While all this is going on, this is Doc 206. This is the government's first request for an extension of time. And they're saying that I filed an exceptionally lengthy and detailed petition under 2255. I'll take that as a compliment. And I've also filed a discovery motion and a legal memorandum. And I've also asked for time to perfect my motion once I get discovery. So I'm asking the court to make my defense counsel hand over my file, which he's refusing to do or won't respond, and the court says no. I said I need copies of my transcripts for here, here, and here, and the court says no. And here's something interesting. The government quoted, in this case, a transcript, in fact, transcript either 128 or 129, again and again against me. And nobody that I asked on the street could find this transcript because it wasn't available. The government didn't make this transcript available until about 2 days ago when I called the court and made a bunch of calls and complained. And now finally, it was for the first time available on PACER, even though in this exact 2255, where they say that the government will benefit from an extension of time. The government's already expended considerable resources, and what does it say? For example, the court may dismiss some of Spencer's claims without the need to take or see further evidence. And basically, what does it say about discovery request? It appears that Spencer must receive every document in this case, whether in the possession of the government or Steve Bergeson's. Right? That's just what I said, right? I said, however, the statutes and its rules, parties entitled to discovery only for good cause. So they're saying that, there's no good cause here for discovery. Okay, so this is Doc 209 now, right? The other one was 206. This is the government's final motion for continuance in my 2255. They won't give me discovery. Here's what they say. They say, Spencer's Section 2255 petition wants a thoughtful response and refutation for the United States, well grounded in the record of this case. This is what they say. Spencer, as the court is aware, is a bright, tenacious defendant who's made numerous claims which, although not meritorious, are not gibberish. Many of his claims assert facts which are belied by the record. That record, which includes over 200 filings and a 3-week trial, which Spencer testified should, in the government's view, be cited and relied upon in the government's refutation of Spencer's claims, and the court determined to deny some or all of them. Excuse me. Okay, so they're saying they need more time and they want to respond from the record. The justification for delaying me and not giving me discovery is because most of my claims are belied by the record. So they're going to use the record to prove me wrong. That's what they're saying here. Okay, let's go back to Doc 148, the trial transcript, real quick. Was that a computer expert that works for the IRS? Did you specifically identify to that computer expert? Did you give permission to that computer expert? Okay, let's go back now to the government's well-founded response from the record. Okay, so here's the government response. This is Doc 215. United States response, opposition to Spencer's motion to vacate, set aside. They finally filed this on May 30th. And it says here, admitting computer metadata. And I said, there was no computer metadata because there was no computer. All you guys did was print off some stuff that you said you got off my computer, and none of it could be checked or verified, and you had your agent telling the jury it came from me and he's an expert. This is their well-founded from the record. 215, Doc 215. Spencer also claims the court did not follow proper procedures in admitting testimony about computer data in violation of his rights. Spencer argues that IRS Special Agent Scott Larson's testimony on computer metadata is inadmissible because it fails to meet Daubert standards. An evidentiary question is reviewable in habeas proceedings only when the alleged error infringes a specific constitutional right or is so grossly or conspicuously prejudicial that it fatally infected the trial and denied petitioner fundamental fairness. Now, this again went to the government's crucial piece of evidence that they say they had on me. It was this resume, right, that I was going to give to the mob boss or whatever. And we'll go on. Here, there was no Daubert violation. Larson did not testify as an expert witness, but rather as a fact witness with technical knowledge. Computer evidence is routinely introduced by field agents in this way. Spencer fails to meet his burden. Okay, let's go back to Doc 148, the trial transcript, real quick. Was that a computer expert that works for the IRS? Did you specifically identify to that computer expert? Did you give permission to that computer expert? Okay, let's go back now to the government's well-founded response from the record. Let's go back to 148, the transcripts. They're still talking to Ernie. He says, one of the things that was retrieved from that computer was a resume. Ernie's answer, okay. Do you remember seeing that? Answer, I was shown a resume by those two gentlemen there later on. Do you know if Mr. Spencer ever used that resume? Answer, I'm sure he might have. I don't know for sure though. And here he is on cross. What I really want to show you here is right after Mr. Kidwell and right after they refer to Mr. Larson as an expert, no less than 3 or 4 times, immediately then Mr. Larson takes the stand. There's no break. There's no break in the jury. So Ernie's excused, the witness is excused, and Scott Larson comes. He's going to do his testimony. What is your title with Internal Revenue Service, Special Agent? Also computer investigative specialist. So he's saying he's a special agent and computer investigative specialist. You have a specialty, and what is that specialty? Computer investigative specialist, or CIS for short. And he talks about he's been doing this for 9 years. He's had 6 weeks of training plus some recovery training in Washington, and he gets 2 to 4 weeks a year. 2 to 4 weeks. So he gets about a month of training every year. At some point, he went down with Steve to get this computer, and it was relating to me, they claim. And he basically goes on, he basically tells the jury that, this is my resume and I made it.
And he also tells the jury that I'm falsifying documents, and he gives, a real expert explanation. On page 234, he's talking about a document in the metadata now again. That's just his report of metadata. We don't have any actual metadata. That was authored by me. And he says that this document is in a format. It is in Word, but it should be in HTML. So if this document, he says, was authentic, it wouldn't be in Word, it would be in HTML. And so the fact that it's in Word rather than HTML proves that, this is a falsified document. Now, here's my question to you. Why would the jury believe him? Why should they believe? Oh, because he's an expert. He's a computer expert. That's the only reason. Why? Okay, he said that. It should be and all of this and that. But why would the jury believe him? Okay, I could say that, right? Or I could argue that's not true, which I did. But why would the jury believe the expert? That's the question here.
This is clearly a witness who was put in front of the jury as an expert. That's very critical here. Now, you think at least the judge, right? This is the same trial judge in my 2255. He saw the trial. He knows what I'm talking about, right? He's going to be able to see through that. He's going to be able to say, hey, government, you said well founded from the record, and he's going to say something, to that effect, right? Is that what y'all think? Okay, here's the order. This is Doc 223, and this is now July 21st. So some time's passed. Enough time that the judge should have been able to see this, right? And look at the record. The government asked for a bunch of delays so that their response could be well-founded in the record. And we see that what they say doesn't even come from the record. They just make an argument, and they say that Scott Larson testified as a fact witness with technical knowledge, although they referred to him as an expert a bunch of times. And so if we go down, I want to say it's either page 6 or page 13. In this document, you could get off Pacer. It's 223, case 10 CR 00326. And he kind of basically paraphrases my claims. Remember, I had a long, extensive, detailed 2255. Here, the judge, he puts them into 5 general claims, apparently. And when it comes to my argument, this is what he said. He puts it in a footnote. My argument about the government, this isn't even worth real discussion. This is dismissed in a footnote. Spencer also argues that trial counsel provided ineffective assistance by failing to challenge the expert testimony of IRS Special Agent Scott Larson on the basis of Dauber. Larson testified, however, as a fact witness with technical knowledge. And then, literally, they quote the government's 215. That's the government's response. So I guess the government is just believed then, because the court, even though as we go, this is their order. It's 2 months later. They had some time to verify this, but didn't need to. Just dismiss it in a footnote. And that's it. That's the end of your claim. And they'll say now that you've already raised it and you can't raise it again, right? That's what they'll say. And also, this is the same judge that denied me discovery, wouldn't let me have the record, right? So this judge knows that I don't have access to the record. So he's like, well, this guy doesn't know what the record is. He's just saying. He's, denied, right? And that's what they're going to do to your family. That's what they basically do to all your claims. I raised a number of claims before the appellate court, claims that they just ignored. They're on the docket. Some of them are. Another one's not. Right? Because they also will just not file your stuff. And then you'll get to your 2255 and you'll be told that, you didn't raise this stuff on direct appeal. And so your time bar. Here, Spencer cannot demonstrate cause for the default with regard to his arguments that the prosecutor posed improper and unfairly prejudicial concerns during cross-examination, misrepresented facts, right? Because he's saying I should have done all this on direct appeal, which I did. And it's actually filed in the docket on direct appeal. Okay, so this is appeal in the 8th Circuit Court of Appeals, 11-34-63, docketed November 14th, 2011. We'll go down to the docket. This is all the entries in the docket. And we're going to go down to when I first send a letter from appellant Anthony Spencer regarding status of appeal. This was on February 24th, 2012. I said, I don't know what's going on. No one's telling me anything about my appeal. My attorney's not communicating with me. And go down a little bit more. Another letter from me regarding attorney Steve Bergeson. This is now March 6, 2012. I informed the court that I'm terminating Steve Bergeson. He's not representing my interests. Here's my termination of, accept this writing as notice of termination of legal services from Mr. Bergeson on behalf of John A. Spencer. Again, this is March 6, 2012. Okay, so that's number 1. Tell me what's going on. We go down to 4/2/2012, April 2nd. Motion to clarify by Mr. Spencer. Motion for writ of mandamus by Mr. Spencer. These are documents I filed. Clerk denying motion for writ of mandamus. Denying motion to clarify. We keep going down. 4/24/2012. So April 24th. Tendered title. Declaration of material facts for attachment and inclusion received by appellant Mr. Anthony Spencer. So here I'm sending in stuff and I'm saying this is what I want in my appeal. Supplemental facts in support of. Same day. One of these is locked that you can't even access it, which is crazy. Another one was never filed. This document, Declaration of Material Facts for Attachment and Inclusion, it was filed in both the Circuit Court of Appeals, 8th Circuit, and the U.S. District Court. It was filed in a direct appeal 11-34-63, and it discusses, among other things, prosecution's unlawful conduct. The prosecution through the intrusion unlawfully. Okay? The government's conduct in this matter was manifestly and avowedly corrupt. Okay? That was filed and received by the 8th Circuit on April 24th, 2012. We go down now to June 7th, and this is a full week before 6/15 when it was argued, and you might say that was the end. You can't argue anything else. So a full week before that, I file another document, not getting any feedback, not getting any, yes, we heard your arguments, no, we didn't, you can raise them, no, you can't, no feedback. Notice of declaration of intent for presentation and appeal. These were all the issues I wanted raised in appeal right there. This was filed on 6/7/2012. And again, here's the docket, 11-34-63. Come down here, and we've got 3/6 letter from appellant Mr. John Anthony Spencer, the one I just showed you. And we've got, let me show you this other document right here, the supplemental statement, notice of declaration. This is 6/7. Remember, this case didn't get argued until June 15th, 2012. So all this stuff is at least 2 months before it was even argued. June 7th right here, because this is about a week before they argued the case. It's a couple months from when I first started filing things. So diligence in filing this stuff, notice and declaration of intent.
Okay, so keep in mind now that I've been telling the court I can't get a hold of my attorney. He's not responding. I don't know what's going on with my case. I'm firing my attorney. My attorney didn't raise the issues I wanted. These are my real issues. No one's responding to me. I don't know when the case is going to be argued. I don't know at this point when I file this that the case is going to be argued next week, but I do know that this was to the court before they did arguments where they might say that was the deadline. So this is again 11/34/63, and so I'm basically saying that Steve Albert's not made one attempt to communicate with me. He's trying to mute me from these proceedings. And I'm just going to go down. We're talking about conspiracy. I'm saying that the guy writing the government's appellant brief is basically misstating the record. I'm talking about inappropriate. The prosecutor in this case did not discourage from attempting to prove the jury the defendant is also guilty of tax fraud, like inappropriate comments by the prosecution. This is all about prosecutorial misconduct, almost prosecution for the same offense. Let me see here. This conduct being manifestly and avowedly corrupt. Again, we're talking about the prosecution. We're talking about the William Hogle defense tax attorney cooperating with the government. Once he does that, imagine you get paid by someone as an attorney, that you take a retainer from them and you tell them, yeah, I'm your attorney-client privilege. And you're also a CPA. So the government comes to you and gets you to flip and you say in court that you were just working as a CPA, not an attorney. Once you give your clients information up, you're going to have to continue. You can't get out of it now. You're going to have to continue to say that. And I'm just wondering, right, when they were thinking about how to get some evidence on me with the computer and then flipping my attorney and getting him to say he's just a CPA, do you think this is at the same time, maybe when they're having those 150 meetings? So here it goes. The intrusion of client privilege. Prosecutor resulted in failed variance, improper comments, insinuation by prosecutor, being denied a meaningful access to member of my defense team, namely my tax attorney. So the cumulative effect of all of these things, I go down here to the bottom. And presumed innocent as the co-defendants were targets of other investigations. The prosecution basically lied on me, is what I'm saying, right? So you can read this document, but what I'm trying to show you is that I put all this stuff, all of these claims into this. All of these claims were submitted to the court in the that they say I didn't record claim before the conclusion of direct appeal. Oh, here it goes. And this is important here. It says here, did you see this guy? Did you hear how well he can articulate? This guy can talk the stripes off a zebra. Okay. Now that's important because I'm going to go back and show you something. This is filed in 2012 before my direct appeal is over. Now let's go back to my 2255 time again, right? We're going to actually go ahead from the direct appeal, so go forward, but back in time from now. And this is document 215, right? This was filed in 2014 as their response to governments to my 2255. We're going to go down to page 25. And one of the prosecutorial delivering improper closing arguments, right? This is one of my prosecutorial misconduct claims. And I'm talking exactly about talking the stripes off a zebra, right? Same thing that I was talking about in direct appeal, right? So these are the prosecutorial misconduct claims that we're talking about at the time of my 2255 proceeding. So here you'll be, or your family member will be, wanting a fair adjudication after a rigged trial. You'll have tried to get yourself argued on appeal to no avail, and you'll be in your last chance, your 2255. You're going to get an order like this. It's going to come down and it's going to deny you or your loved one's claims, specifically claims you raised on direct appeal, right? Like elicited false testimony, made improper closing arguments, and you're going to be told that I should have raised this on direct review and I cannot demonstrate cause for default or actual innocence. And again, it's important because I've been claiming actual innocence the entire time. And so the reason I say that I've been claiming actual innocence is because at every step, every single step from pretrial to trial to post-trial pre-sentencing, sentencing, post-sentencing, direct appeal, post-direct appeal, 2255, civil case, I've maintained direct innocence, even though they've consistently said that I'm time barred from raising it unless I can show this extremely high level, some insurmountable burden of proof that they want to place on me, because they say that either I've already raised the claims, like with the computer expert, they'll say I've already raised that claim. And you saw the quality of the adjudication there. I just showed it to you. Then they'll say that you're time barred from other claims. And I just showed you how they do that. And if that's not a lie, if you didn't just see for yourself the lying, the rigging, right? And if that's true, shouldn't you ask yourself if everything I'm saying is not true about these cases? Because I think every federal petitioner who's filed a 2255 has just gotten, an unconstitutional adjudication. It hasn't even been looked at. It's just been denied in most cases, right? And it just is probably reason number 100 for you to do your jury work. I'm just asking now, could it be reason 100 for you to do your jury work and nullify all federal trials? Because if you don't, and you made a mistake and they are innocent, and the government cheated and rigged and everything, now they get into appeal. They're not going to get a fair appeal. They're not. They're going to get censored and silenced. They're going to get shipped and given diesel therapy and traveled around. And by the time they get off the bus, they're not going to be able to do anything with that appeal. It'll be over. And then when they get to their 2255, their last chance, they're going to be told that they're time barred. And even if they're not time barred, the government will lie, and the court will just accept that lie and dismiss you or your loved one's petition. Think about it. Did I not just demonstrate that to you here?
And here we have the district court judge, same judge in my trial, right, telling me that I didn't raise these on direct appeal and I can't demonstrate cause for default. as to these allegations. And this is 2 years after that. On July 21st, 2014, he's telling me that I didn't raise it. And he's telling me down here in a footnote that my claim doesn't have merit. Where was it? It was on page 13, right? So this claim that was apparently well-founded in the record by the government, so well-founded, he just adopts what they say, dismisses it as a footnote, kicks it out of the way, and then comes back up here, tells me I'm defaulted. And this is 2 years after I raised those claims.
So anyway, you see the rigged nature of it. You see their scam. You see what they did to me, right? I'm going to keep exposing it. I'm about to bring a monster case against the U.S. federal government, a monster case, right? They're going to try to say I'm time barred. They're going to do everything they can to stop me from developing and presenting this case. And they're going to say that, it doesn't shock the conscience. But that's where I need you. Leave in the comments. Is your conscience shocked? Are you shocked? Is this appropriate? Is this okay? If this is what's going on, does it trouble you? Put it in the comments, man. We get enough comments. We get enough people to see this. They're going to have no choice but to have that hearing that's going to exonerate me.